Good morning. I'm Rob McKenna, former Attorney General of Washington State, and your moderator today as a partner at Orrick, Herrington, and Sutcliffe to talk about the intersection of data privacy and liability. This is one of the fastest growing areas of liability concern and activity, as you all know. And we're very fortunate today to have three panelists to address this issue from very distinct points of view. From the private sector, from the financial services industry, where Tanya Cunningham is the Chief Privacy Officer at TD Bank for an entire week already, but previously was at Amex and at PayPal, so brings a very broad and deep background around data privacy issues from technology and financial services sectors. We have Kiran from the Department of Homeland Security, which is obviously deeply concerned about cybersecurity. By the way, Kiran, I brought my copy of the letter I got from OPM informing me that, yes, I too was breached with that one breach. So we're looking forward to hearing your perspectives today. And Attorney General Reyes is with us as well, presenting the state point of view, the state regulatory investigative point of view, not just from a consumer protection standpoint, but from a law enforcement standpoint as well. General Reyes has a very special background coming into the AG office, where he's been serving for several years, having been the general counsel at a venture fund, having been in private practice, being one of the most tech-savvy AGs that we have. He'll be bringing his perspective as well. So what we're going to do is open up with just brief comments from each of our panelists, starting with Ms. Cunningham, who will be talking a little bit about her concerns and perspectives as the Chief Privacy Officer for a large bank and as a former CPO for other companies as well. Tanya?
Thank you. One minor clarification, well, two things. First and foremost, my comments are my own and not any of my current or former employers, nor am I speaking for the entire financial or fintech industry, because heaven knows they wouldn't want me to. But secondly, my role is Chief Privacy Counsel, and I frankly owe my career to the intersection of data breach liability and some of the issues that we're looking at, because financial institutions, fintech companies, and others are now in a role where they really do need in-house legal expertise on critical privacy legal issues. So the CPOs of these companies are generally my main clients, but I focus on the law and data security issues if and when there are breaches. I'd like to talk just a little bit about what companies realistically can do and are expected to do these days, because the issue of data breaches and liability continues to be a material one for companies, and one that can truly impact their bottom line, and not just from a financial perspective, but there are also reputational concerns about the loss of future business, concerns about unpleasant interactions with regulators. And you see companies of all sizes and levels of sophistication continuing to wrangle with these issues. One of the best perspectives I have heard on this was by a former general counsel that I worked for. And he said, really, companies are kind of faced with a decision. You know, you're at the top of a very large cliff. And the question is, do you want to build a really solid fence at the top of the cliff, or have a really strong ambulance service at the bottom? And for early in my career, I saw a lot of companies seemed fairly satisfied to have the ambulance at the bottom of really good outside counsel partners and others to work with when there was a breach, and that was considered preparation. We've seen over time an evolution of the standards that are required of businesses that deal with personal information. And you've seen kind of a rising of what is considered to be table stakes at these days. So when you look at issues of, you know, what are some of those top of the cliff things that are now considered to be fairly normal that at one point were more cutting edge, things like encryption of personal information, widespread training of employees, having some kind of data loss prevention program, certainly incident response plans that are not just in notebooks on shelves, but are used frequently and updated to reflect new threats. Having folks like CISOs and CPOs, and yes, now even Chief Privacy Counsel, to add depth of knowledge and experience to what the institutions are facing. And then as far as the ambulance at the bottom, again, the sophistication around that is not just having a good outside counsel partner, although that is absolutely critical, and those are arrangements that you want to have well in advance. But things like having call centers set up that you're going to work with and knowing things about the various credit reporting agencies and mailing houses and how fast can you send out 1 million notifications versus various means. And of course, knowing having deep relationships with entities that can do forensic analysis as well as crisis management. So just 2 other very quick points before I close my opening. The costs, again, are real. The average cost of a data breach in just 10 years has doubled. So for the smaller, everyday data breach issues, we've gone from about $3.5 million to $7 million. And the average cost per record has gone up, according to the Ponemon Institute studies, which have been looking at this for quite a while. It's now at an all-time high of $221 per record. So when you start to look at significant breaches, the dollars add up quickly. And of course, that impacts the bottom line, and it impacts resources that can be used to otherwise surprise and delight your customers.
Great, thank you. Kiran, what's your perspective from the Department of Homeland Security?
Sure. Well, first of all, I just want to thank the Chamber and the Institute for Legal Reform for putting this on. It's obviously a very topical issue and one that, we get questions a lot from lawyers in particular on what are the things I need to be thinking about when it comes to data security and liability, and how do I even think about these issues? I mean, a lot of times we see on the newspaper day in and day out just breaches or other cyber events, and how do I think about those? How do I even put my head around it? So one of the things I like to do is talk a little bit about a framework for even thinking about cyber risk. So especially from the perspective of threat actors. If you're a company, how do you think about threat actors, and how does that impact your vision of your liability, your potential liability? And so I tend to divide the threat actors, external threat actors, into 4 different buckets. So vandals, robbers, spies, and saboteurs. And the idea behind a vandal is it's somebody who's trying to deface your website or otherwise prevent your customers from accessing the services that you provide. And the way that you potentially deal with that risk is going to be very different than another threat actor like a robber. A robber is there to make money, and the way they tend to make money these days is by going after personally identifiable information or other information that you may hold in your company that they can then go on and monetize. Spies are a little bit different. They're after national security information or your intellectual property that they're going to send overseas and try to monetize that for their own national purposes. And finally, saboteurs, which from a national security perspective is something that we take very seriously. Those tend to focus on areas of critical infrastructure companies where they set up systems where they could potentially do some damage down the road. And so when you think about these 4 different categories, as a lawyer and as a company, your defensive strategies might be very different depending on the type of threat actors that are most likely going to come after you. For some companies, they're much more worried about the saboteurs, and others, they're much more worried about the robbers. But one of the things we've seen is that one of a really great strategy for combating these type of threat actors is information sharing. And information sharing is a great example of the intersection between data security and liability. So one of the biggest issues that companies have had with information sharing for a long time is, am I going to be liable by sharing information about things that I see hitting my networks? And so last year, Congress addressed these liability concerns by passing the Cybersecurity Act of 2015, which included the Cybersecurity Information Sharing Act. And one of the main things that act did, I tend to refer to it as CISA, although some people call it CISA, is that it provided liability protection for sharing pursuant to the statute. So what you can do now as a company is share information with other companies or with the federal government about cyber threat indicators or other things that you are seeing on your network. And the reason that this is really important is because it allows situations where, for example, if your company, say a financial industry company that sees a robber trying to attack you and steal your information. You can immediately share that information with others in your sector or others just throughout the country to say, hey, here I see this robber, they're trying to do this, you all should protect yourself. And at DHS in particular, one of the things that CISA did is said that we had to create this system where it was automated indicator sharing. So we can actually provide this in real time, this real-time information. And to give a topical example of this, last week in the news was this issue of distributed denial of service attacks, the DDoS attacks using essentially cameras and other internet-connected devices, generally referred to as the Internet of Things. And one of the things we were able to do at DHS is pretty quickly send that information around to those who are using our AIS system, the Automated Indicator Sharing System. And so it allows people to improve their data security, but at the same time, Congress has put in liability protective measures, so liability protection from civil suits, from antitrust suits, and also from privacy too. So there are mechanisms to protect privacy and personally identifiable information when you're sharing with the federal government and other private sector companies. And so I think these type of things we're starting to see not only the intersection of data security and liability, but also means of trying to lower potential liability while improving data security.
Great, thank you very much. Sean, what's the perspective from the state AG point of view as the dual role of consumer protection, but also law enforcement?
Thanks, Rob, and thank you all. It's a wonderful opportunity. I want to thank the Chamber and ILR also for letting us as regulators interface with good corporate citizens in terms of how to help you prepare and minimize liability, both from a regulatory level and a civil liability level. So we approach it at the state level. We're much more in the ambulance business, but we like to also be in the fence building business. And primarily, I think almost every state right now has data breach reporting requirements. In some cases as strict as federal laws, in some cases not quite. But you have obviously some pretty strict federal laws governing the management of sensitive information, from personal information to financial information, health information. And then state laws, for instance, in my state of Utah, we have laws specifically governing education, student information, health information, and financial and personal information. Requirements for reporting to agencies, usually an Attorney General's office or Department of Justice in your particular state, on top of any federal requirements. And then, of course, you have, besides these statutory concerns, civil liabilities. And again, it's hard for me to stay only on the side of regulators because I have spent my entire career in the private sector. In some cases, bringing large tort cases, and in other cases, defending against large tort cases. So a lot of experience when it comes to these types of liabilities. And I think if I were to try to put myself in your shoes, general counsel, CIO positions, really any board level position or officer level position, because more and more lawsuits are being brought against directors and officers for their fiduciary role in preparing companies for these types of crisis situations and then their response to those situations. But if I were to put myself in your shoes, I think everything that you would do to immunize yourself from civil liability, be it breach of contract claims, be it shareholder derivative lawsuits or tort claims, I would recommend in terms of helping to protect yourself from a state regulatory standpoint. So what does that mean? That means being very proactive. I just had the pleasure of meeting with about 14 different companies in the Bay Area last weekend. And these are all either headquartered there or have a major presence and are major tech players. And a lot of our conversations centered around what can we do together proactively to help protect the corporations and the people that they represent, their shareholders and also their consumers and clients. And so being proactive is, again, I think that is going to help you, whatever those are, from firewalls down to passwords, just to demonstrate that we practice or try to practice what we preach, because breaches are ever present, not only from outside threats, but mostly from internal negligence or threats. We in the AG's office are beta testing for the entire state facial recognition passwords to obviate some of the risks with unauthorized access. We are also beta testing digital information management technologies, again, to put a much tighter cocoon around who has access to documents through all sorts of other authentications that they have to demonstrate before they have access. So again, from my standpoint, we will investigate. We used to be able to investigate, I say we representing all the state AGs, every breach case it seemed. Now they're so numerous that we may not, but expect that we will. And we're, again, approaching it from a deceptive trade practice view, a consumer protection lens, or compliance with the specific state requirements in your respective states. Be proactive not only in terms of creating as many defenses as you can, but if there is a breach, in terms of communicating with the AG's office or whomever you're required to under state law, and also to whoever has been affected. Again, those are the things we're going to look for. Were you timely in effectuating, contacting, and minimizing any damage to those who've been affected by the breach? Were you timely in contacting us and being cooperative and interacting with any investigation we might undertake? And what did you do to begin with to help protect this from happening? I think those are the three critical issues.
Excellent. So a question for each of you. Tanya, for you, to extend the metaphor of higher fences versus ambulances at the bottom of the cliff, how do you know how high that fence needs to be to reduce your liability exposure, since the bad guys are constantly building taller ladders to get over the fence?
Great question. Thank you. I think it's an ever-evolving standard, and so what worked certainly 10 years ago, 5 years ago, even 2 years ago may not be sufficient today. And one of the things that we have to do is stay on top of other breaches that are occurring, to find out where the threats are that we may not have thought of. The difficulty for businesses and any holder of personal information is that we have to be right every single time, and the bad guys only have to be right once in order for there to be an issue. So the odds aren't in our favor, but what we truly try to look at is, what are suggestions or requirements that come out in NIST standards, in publications from DHS, in publications from the various state attorneys general. We look at the CFPB and the FTC, obviously try to look at trends in the law, and then although I am not authorized to operate a remote control at home, I try to be tech savvy enough to understand what's happening in new product development, to identify where there may be new and unidentified gaps. So it's a constant learning process.
Terrific. And so as part of that learning process, Kiran, companies can look at DHS as a resource. You suggested, for example, that information sharing by companies with DHS is a good strategy as we try to pool intelligence about emerging threats. What other advice do you have for companies in terms of how DHS can be an ally of theirs as they try to prevent breaches and then deal with them when a cyber security event does occur?
Sure. So from a prevention standpoint, there's actually a number of services that the DHS offers that are free to the private sector. So that includes things like cyber hygiene scanning, risk and vulnerability assessments, providing sort of the best practices and other information that we've gathered through our work with a number of different private sector companies. And also as we work to figure out, those different threat actors that I discussed, what are the things that they're doing, that's information that we can provide. So that's sort of one, I think, big piece of it. The second big piece is sort of after an incident. So, earlier, a few months ago, the president issued Presidential Policy Directive 41, PPD 41, which talks about the roles of various government agencies in a significant cyber incident. And as part of that, we've really tried to divide up and tried to make it descriptive of what are the different things that all the different agencies do. Because the cyber issue is so broad and so vast that no single agency has all the particular expertise that's necessary in terms of dealing with a significant cyber incident. And so in that context, we have essentially the FBI and a portion of DHS, the Secret Service, that works on what's called essentially the threat response, and that is basically put the bad guy in jail, put handcuffs on the bad guy, figure out who the bad guy is. The other piece that's really a DHS primary responsibility is the asset response, and that essentially is how do we get the private sector company back on their feet? How do we ensure we can go in, mitigate the damage from the cyber incident or cyber event to try to get them back on their feet? And that's one of the things that I think DHS really excels at as part of our sort of voluntary cooperation with a host of different companies is if something bad happens, we're going to be there to try to help you address it, get it off your system, and ensure that we put, to use the analogy we've been using, our fences back up again and put them higher.
Who do they call DHS, Kiran, if a company or the chief privacy counsel of a company is looking for advice, wants to know more about the various services and products? Who should they call at DHS?
So we have a cyber center. It's called the NKIC, which is our 24/7 cyber operational center. And in fact, out on the table outside, we have some information for folks in terms of contacts, information of who to call if you have questions. We also have a website that actually details different, if you want different services, what are the contact info. But generally, for example, in a post-incident world, one thing I say is, a call to one is a call to all. So the idea is not so much that you need to have a very specific person that you call depending on the incident. What we tend to see happen, which I think makes sense, is that in the regions where companies operate, they have great contacts. They might know somebody from their local FBI office or their local Secret Service office, and they have a trusted relationship with that person or persons. And if there is a cyber event or cyber incident, you should feel free to call that person, and the government on the back end will take care to ensure that the right folks are aware and can come and help in case of a significant cyber incident.
Fantastic, thank you. General Reyes, I think it'd be good for people to hear a little bit more about what best practices look like when it comes to working with an AG office. So let's break it into two parts briefly. One is, what can I do in advance of suffering a cybersecurity incident, and what should I do when I find out I have been hacked and data has been compromised, vis-a-vis your office or any Attorney General's office?
Sure. Let me quickly just address the latter first, and that is if an incident occurs, there are usually designated officers in the state AG's office to accept reports. But again, don't let a lack of clear communication deter you from making sure that you get that reporting done as quickly as possible. So if you can't reach the right person, call the AG, him or herself, and make sure that you're on record, that your company has immediately or as close to immediately. Sometimes there are investigations and there are exceptions at times for law enforcement agencies, if they're working with your office, to defer reporting for a reasonable amount of time. But do whatever you can. You want to insulate yourself by being on record and starting immediately to work. AG's offices are very proactive, and when a breach occurs, we want to work with you. And it's a cooperative, collaborative relationship at that point, or at least that's our view of it. We will worry about and deal with liabilities later on, and of course you have to balance again. I always, even having come from being in your shoes, encourage full transparency. There's nothing that's going to be gained from trying to hide anything. We'll find it out later on anyway, and so work with us cooperatively up front. Now, in terms of what you can do beforehand, I will maybe harken back to Rob's last question, and DHS has great resources. Other agencies at the federal and state level, some of you may have worked with the FBI and trainers that they have, like Frank Abagnale from Catch Me If You Can fame. Frank was just in our state doing training. It's free, it's very insightful, very helpful. Have your AG come to your place of business. I recommend it all the time, and I know your counsel probably gets a little nervous about that. But again, in the terms of being transparent, if you've nothing to hide, I think that those are some of the most constructive opportunities to have AGs and state regulators understand better all that you're doing to protect information at your business. That will help you in the long term. And so those are some quick things that I can think of in terms of dealing with regulators beforehand and then being immediate in responding afterwards. And also make sure you do everything you can to reach out to those who've been affected. That's your responsibility, and we'll hold you liable for that.
Well done. I want to thank ILR for organizing this particular panel, and also thank them on a personal note for the Pearl Jam music that was playing when I walked in the room. I thought, God, they knew the Seattle Kid was going to be here. They're rocking out the Pearl Jam. Liability reform is cool. Don't let anyone tell you differently. Thank you all very much.